I do see that.
Yeah, I had to move my desk. I got tired of not my desk. So I didn't put my name in. I apparently took my name out of this too. How are you guys doing today? Doing good? I'm looking forward to talking about some immigration stuff. So
Yeah.
Jesse, I want to ask you about the WashTech case. Got maybe a little time to address digest it a little bit. And our good friend Cyrus Mehta wrote a very interesting blog comparing the WashTech case to the DACA Texas case.
Yeah.
And I found it as a very interesting comparison. Now, obviously the judge who wrote the dissent in WashTech was on our panel, Judge Henderson, right? So she wrote the dissent in that case, which is all about, what do they call it again? Big decisions? What is the word they used? It'll come to me in a second. Major questions. So the DACA case, the Fifth Circuit, when the government says, hey, we relied on this statute in, I think, 241, that gives the government broad authority to write regulations to enforce the rules. And in the WashTech case, similarly it said in 103A of the statute gives us broad authority to do OPT. And in the WashTech case, the court said, the majority didn't even address it. It was major question was not in the majority decision. But Judge Henderson said, I think the district court needs to look at that issue. Now, the major question thing, it's just literally invented out of whole cloth earlier this year by the Supreme Court. And it's designed, near as I can tell, it's designed by the conservative majority to limit the power of the federal government.
Right.
What they can do. By the way, you may have, I do want to set this aside. I have been listening on and off to the pig case today at the Supreme Court.
I know it's big.
There's been some great Twitter threads on the pig case.
Is this the one with the onion?
No, this is the one where California passed a ballot initiative and said that pigs must have 24 square feet of space to live in, as opposed to living in a sow cage where they can't turn around.
Well, I'm a vegetarian, so as far as I'm concerned, they should have all the space they want.
Yeah, well, apparently by California voters too, but it apparently wasn't going over big with Alito. And Alito and Sotomayor were having quite a discussion about it, as did Kagan and Jackson. So it's who knows what they're going to come down as, but it's interesting because it goes to the same issue. I mean, what can the federal government rule on? So in the pig case, the conservatives are arguing, federal standard, only the feds can do that. And yet in the immigration case, they're saying, feds can't do that. It's just fascinating to me.
There's this situational sort of arguments that seem to happen where, and immigration is a great example of that, where, people will take completely different philosophy, argue a completely different framework as far as, whether the issue is whether they're pro-immigration or anti-immigration, and they'll argue whichever way it works for them on there. And I think we see that all the time where, we say, well, okay, the court, this is the precedent. This is what what they should be doing based on what their philosophy is. Like on this major question saying it would mean in a lot of cases that the government can't do the kind of stuff that we're talking about. But if they, is that the overriding issue for these judges, or is it getting to a decision that helps immigrants or hurts immigrants? Is sort of, it seems like they will not necessarily be consistent in order to get the end result that they want on there.
There's that old saying, Greg, a foolish consistency is the hobgoblin of little minds. That's what we need to get here.
But that's what I think makes a lot of this stuff unpredictable, is that it's not necessarily the law that's going to determine what the outcome is. It's going to be there in the politics.
Yeah, well, I mean, the other thing too, though, is, I think you have to look at it because it cuts both ways. Right now, we have an executive that we quote unquote is our friend. We used to have an executive that was certainly not our friend. And so really it's who do we want to defer to for our immigration lives? If I'm a client, right, who do I want this friendly administration making the rules and getting quote unquote deference? Maybe today I do, and maybe 2 years from now I don't, and maybe 2 years before that I don't. And so, you have to, so it can cut both ways, and I think if we're taking our guide from the Supreme Court, we need to think about how can we use this consistency to help us. And so, yeah, WashTech, maybe it wasn't deference, but it was the most reasonable decision for all the reasons why we need these people to be working, right? So it was, I don't care if you defer or not, but it's the right call. Henderson, she's not going to go. She's just taking a political view to her judicial life. I mean, that's just a political view. Right. But I think for us as immigration attorneys or litigators going forward, we have to appreciate that you have a majority of the Supreme Court who want to not defer, and we need to hold them to that, right? Right. That if there's decisions that we need to be making as litigators, we can use that, the West Virginia case to say, well, listen, as soon as I know that there's an ambiguity here, let me explain why what they say is wrong and what we say is right. And that opens a door, actually, because oftentimes it's like when you file an AAO appeal and ask for a reversal, okay? And they're going to defer almost 80 to 90% of the time. So why do you go to federal court? Well, you go to federal court because you don't have that. And you shouldn't have it. I mean, you have APA type deference, but if it's a legal question, you should get none. And the Supreme Court it transcends immigration. I mean, this is a movement at the Supreme Court where this type of, rubber stamping of this administrative state is over.
Yeah, well, that's Gorsuch's big thing, and although some of the stuff he said today was really interesting.
Well, I'll tell you, I've told you, right? So, I had the benefit of arguing before Gorsuch in Denver one time as a government attorney, and I was not prepared for his view of the world, and I was defending an attorney general decision. And he said, well, and I was telling him he had to, it was totally acceptable for the attorney general to make the decision that he made. And he goes, well, why do I have to defer to him? he goes, and then the other judges on the panel looked over at him like, what? And he said, well, hold on. He said, you've come in here and you've just said that, I have to actually not have a independent view. He goes, last I checked, I'm an Article 3 judge. You tell me why I can't. And I was like, forget. I mean, I was looking at my itinerary to fly back to DC. I was like, I'm not getting anywhere. I'm not going anywhere. But that's him though. And so you have this. So it opens up a door, right? It opens up a door for people who, if you're not going to get help with the agency, then federal litigation presents that door for you. But of course, it cuts both ways. I mean, right.
It cuts both ways if they're consistent in terms of applying that legal philosophy.
Well, let's think about this though, right? So we have, turning to like actual cases that we have this, we know now that that the Department of State did not issue visas according to the law, right? 1153 E, and that's part of we're trying to pierce the veil here on correct what they did with blatantly false. Now it doesn't matter where you sit. That language is ambiguous. Not ambiguous, right? No. So, of course, the remedy is a bit of a reach, but I mean, that is something where, of course, the agency is going to issue an FAQ and tell you that what they did was rational and reasonable, but that's where federal court is really your only recourse.
I think that's called post hoc reasoning when you issue an FAQ after you've been sued. Yeah. Pretty much how it is. I do want to give a shout out to our colleagues who won in the Ninth Circuit recently, this last week, on consular non-reviewability. Our other friend argued for the government in that case, and he lost. And so everybody knows when you sue the consulates, and you can sue the consulates, the seminal case is Supreme Court, Kerry versus Din. And basically what Kerry versus Din said was, look, the government just has to give you a reason, and they have to do it promptly. That's it. And literally that reason could be, you are hereby denied under 212 he's 3A. They don't have to give you facts. But what happened in this case was fascinating. The consulate didn't do that for 3 years. They just denied him and didn't tell him why. And so argument was made. And literally, I think it was either during oral argument or shortly before oral argument, they literally sent him a letter that says, here's why we denied you. We think you have ties to MS-13, all that kind of stuff. And the court did something fascinating. And this was actually shocking to me. Instead of saying, better late than never, there you go, you got your reason. They said, no, it's too late. You got to go back and talk to this guy again. I thought it was a fascinating decision. And it should, let all our colleagues know, you can sue the State Department. They're not following their own rules. So I just want a little click up on the screen now. We're doing onboarding for our wastage. This is for this year's wastage. And not necessarily they're going to waste 60,000 visas, but how they're going to allocate them. We already have evidence from our own plaintiffs that are still left over from Audubon, who are current this year, who are being taken out of order.
Yeah,
it's literally already happening.
Yeah.
We have people with early 2010 prior dates who have not been approved, and people with late 2012 dates that are current that are being approved.
Yeah, not only that they have early priority dates, but like we have one person who's current and filed on October 1st, 2020. He filed his adjustment. So he filed his adjustment ages ago, and he has an old priority date. He should have been adjudicated in Chakrabarty. Or he should have been adjudicated in Madhavan. Why is he still waiting? There's no reason for it other than that they are taking cases out of order.
Yeah, so we're gonna take them to the woodshed here. So sign up, come on board, and we'd love to have you.
Chuck, I will give the update that on the plaintiffs that we had at the end of the day, we have we've had I think 6 or 7 plaintiffs approved since October 1st had current priority dates. We have about, I guess, 4 left that are in that category.
There's and
overall we had 170 adjudications out of 276 applications in Madhavan. So, it was, I think that we clearly had an effect, but obviously we're still fighting for these remainder.
And we keep fighting. That's what we do. I wanted to point out on our EB5, let me find my EB5 little plug-in here, EB5. So today the USCIS issued a notice that if your EB5 when you file is current, so you don't have a backlog priority date, you can file your adjustment. So for our plaintiffs in Jane that are pending 526s, if you are in the U.S. and your priority date is current, interfile your adjustment as right now. Don't wait for the 526. We are waiting on discovery, which I think is the either 18th or 21st that we'll get the discovery from the government. I'm curious as to what we'll see on that, and we'll be working with our friend Matt Galati on that case. But we just kind of wait, and then move on from there. All right. Now there was one other case I wanted to talk. This was the visa fee litigation. For those of you who don't know, we do have another onboarding case.
Yeah.
If during the pandemic you paid a visa fee to a consulate and they didn't interview you, they didn't give you your money back. That's illegal.
Yeah. Or they postpone you in such a they postpone you so that it was basically essentially useless, because say you were coming over for a summer work program,
right,
and they postpone the interview until the following November. That is essentially the same thing. So we're looking for those kind of cases, especially for J1s and F1s who couldn't, who missed the start date of their programs because of delays. And then also, Chuck, I understand that there was one of the consulates in India. No, there was a Facebook live this week from India, and they addressed one of the issues that I think we're going to be covering in that case, which is that people that applied for visas and had a delay of more than a year, the State Department position has been that they have to pay a second time. Even if it was through no fault of their own that they didn't get the appointment, it was the State Department's fault, they still say they have to pay. The Indian consul chief, the consul chief on the Facebook Live said that they were not going to charge again for people in that situation in that country. But I think that's just an audible that they've made in that one location, because I'm pretty sure that that's not the rule that's being followed in the rest of it, unless the State Department has sort of gotten wind that we're going to litigate on that issue and maybe it's changed their policy. But, it's still a lot of people were negatively affected on it and paid a second time that shouldn't have. And
to note, there's no fee to participate in this litigation. We're going to be paid from what we get from the government. So there's no upfront cost for any of our plaintiffs. And, because it's not, it's a lot of money if you're coming from a country which the annual income is very low, but in the grand scheme of things, $150, $200, $400.
Right.
But you deserve to get that money back. And so take a look at this on our onboarding page. And this is actually the link right here. We would love to have you participate with us as part of this. Yep. I would note, my friends, we have dismissed the K1 Manila case. It is over.
Yay.
All the K1 cases are done. We were down to 2 plaintiffs. One withdrew his case, and the other one just is ignoring every communication from the government and us. So, case is over. So, congrats.
Yeah,
we got their green cards.
We're not done with K1s as sort of a, with the cases that we're going to take. We're actually we're going through an evaluation process about it, doing more of that in some of the countries where K1s are still seriously delayed. So I don't want Chuck's comment to make it sound like we're not doing K1s anymore. It's just that the ones that have been pending are now all finished.
One issue that's come up a lot recently among leadership of immigration lawyers is the extraordinary delay by USCIS of provisional waivers. Now, my firm, we do a lot of family-based immigration. We have a lot of these pending, and they are well beyond 2 years.
Yeah.
For no explainable reason. None. CIS has not addressed, other than whining about money, why they have not adjudicated, why it's taking 2 years. It's actually unconscionable at this point. So we're going to be looking at this issue as well. If you are the victim of one of these cases, that your case has been pending for a year at USCIS, keep in mind, historically, this is a 6-month processing time at most. And it's quite clear that the Trump administration basically just stopped adjudicating these cases. And if the Biden administration is not really doing anything to get caught up. So,
sorry, go ahead, Jesse.
I was just going to say, I'm looking at the historical change right now. So it went from 4.6 months in 2017 to 31.3 as of August 22nd. I know that the times are different now and maybe different depending on where. There's only really 2 places, but but this is an agency decision-making process where they're certainly just turning away from handling these, and it's so important. So for anyone who doesn't understand, if you need a provisional waiver, it's a tremendous benefit. Yes, you get to stay in the United States, but you don't get to work. And so the delay in allowing you to go abroad for your immigrant interview and come back, a lot of these people are basically, they've gotten this provisional waiver opportunity because they have immediate relatives, on there, but they cannot contribute to the family. And so a lot of what we do when we look at things is, again, employment status. This has everything. And this is really, this needs to change. This impacts, everything impacts everything.
There's got to be, I don't know how many cases they have pending. There's got to be 100,000 of these cases.
Yeah. Just as sort of a broader question, Urgidoo and the USCIS has been saying since, at least the last 6 months, that they've been on a massive hiring spree, that they thought that they would be fully back to their normal workload, their normal staffing loads by the end of the calendar year. Yeah. So, it should be that we are starting to see processing times moving down and back to pre-COVID normals. So when we're seeing in certain categories where it's getting worse and worse, that to me is that's a management question on there. It's no longer a question of that the things that are out of their control. If they are truly staffing up, then they should be. Then we should be seeing the correlation of processing times really dropping dramatically. But we're not.
Greg, this is called the Peter Principle. Google it. Google the Peter principle. So let's answer some questions that we have here.
Oh, Chuck, can I just
Of course. Go ahead.
Can I
But we
stop
haven't
for-
talked about Ukraine.
Oh,
Yeah,
Ukraine, of course, duh.
This is, again, the Ukrainian refugee case, Shumalina, is about where, there's actually a law passed this year that helps refugees from Ukraine, and it gives them the benefits to the extent of refugees, except for, a couple things, permanent residency being one of those benefits. But in terms of employment and having not to pay or having a free EAD card, no, those were included. And, we have put a lot of work in this, a pro bono case. We've put it out there. We filed a preliminary injunction, a motion for class certification. We gave the government, I guess maybe I was naive in doing it.
No,
but
you were nice. You were nice.
I gave him a week. I gave him a week extension because they basically said, "Hey, we think there's a settlement here. We see your case," and Friday you just got like an infuriating email, and they asked for another extension of 3 weeks, and I said no. And without coming back to us, I actually said no. Can you please respond to our settlement offer? Without getting anything, they file this. This extension, and I got so aggravated. So we responded and opposed it the next day on Saturday.
Awesome.
And I'm so aggravated because these people, because they've also put in a pleading, and this is what really boils my temperature, is that they've said there's no immediacy need here, or it's not a time sensitive case. Well, I mean, these people come over here from a war-torn country and leave everything behind. Congress gives them the benefit of being able to work, and everybody who's probably listening right now knows how important it is to work and provide for your family. And it just burns me up to no end that they want 3 weeks so they can keep violating the law. It drives me insane. I honestly, I can't take it. I'm so aggravated at them. And it's
Jesse, they were notified about. I mean, we talked to them about this in early July.
I know.
In early July, we didn't file the suit for several weeks after we told them what the issue was, to give them some time maybe to fix it, and they just ignored that. And then once we filed the suit, then they're playing for time. They've known about this for a while.
I know.
And oddly enough, the judge has not. Earlier on a prior extension, the judge ruled very quickly, gave it an extension. There's been nothing this time, and
there was a holiday yesterday. There was a holiday.
Oh, that's right. I forgot Monday was a holiday. There you go.
Is the deadline Wednesday for them? I mean, if the judge,
tomorrow,
So I'm sorry, tomorrow. So if the judge doesn't rule with the government, they've got a deadline coming up in a few hours. Yeah,
I hope they're getting ready for it.
Well, I think it's true. That's the last point on this, because this is something where if I filed this, or if we filed something like this, we'd probably get sanctioned. Where you say, I know I'm violating the law, I just need 3 more weeks to change
to keep violating the law.
Yeah, no.
This is they could fix this. There's 100,000, 120,000 still pending. They could fix that in a week. If they just said, they could fix it tomorrow. Hey, you're all qualified to apply. Have a nice day. But they could issue those all in a week.
And what have we been talking about this entire call? We've talking about how they're not managing the processing correctly. And this would free up space for them to do 601As or other things, EADs that they're, on other cases that have to be processed.
All right. The good news is they want us to keep suing them. There you go. You had your chance to talk, Ms. Chadu, but you blew it. Let's take a look at some questions here. Trey Yates, good to see you. Go is nothing to do with DV 2022. They're different cases. So no impact whatsoever. Issuing 55. This is actually a good question. A good comment. So the Department of State has now set the standard. They can issue all the visas. Punto. End of story. They have now manifested the ability to do it. So anything less than all the visas in the future would be open them up for litigation, I think. And Sudeep is also vegetarian. Greg, that's great. Borchabu case, or how it is called, the Borchabu case is over. And because you can't reserve visas, don't exist. The judge recognized that. They've issued all the visas. End of story.
Right.
All right. Where's a handsome hunk Aaron? Oh, we.
What is that? Was that sort of a backhanded
compliment?
compliment? I mean, an insult to the three of us.
That's okay. I can take it. I can take it. Aaron is a handsome man. There's no doubt about that. Aaron is busy with other things today. We do excuse him being with us. Trey wants to know if we provide a consultation for pre-employment visas. We all do client consultations with our clients. That's what we do.
Yeah.
Jess doesn't do employment-based visas, but he'd still love to talk to you about suing them for some reason. He'll figure out a way.
I can come up with a reason.
Ahmed Farhat, hello. Thanks for your efforts. Enjoy your holiday, Greg. Greg's not technically on a holiday.
Wait, what's my holiday? No, I'm at a legal tech conference.
So my question, Greg, did you bike ride there is the question. Did you ride your bike to Nashville?
I took my folding bike in my trunk because it could drive up here.
That's awesome. Hello, Jess. What do you think about Henderson's dissident? I think it meant the dissenting opinion. We already talked about that in the F1.
Yeah.
Do you think Katsas do more politics than law? I thought Judge Katsas was kind of torn by this case.
Yeah, I think he's more inclined to go with the Gorsuch view of, especially when you're talking about reservation and, our argument was that the law actually, there is no ambiguity and that 212F is pretty plain. So I thought Katsas was, he was leaving his political views on immigration at the door, I thought.
By the way, related to all of this on the 212F issues, this legal tech conference I'm at today, the keynote speaker was Neil Katyal, who a lot of people, but he's the lawyer, but he spent a lot of his remarks talking about the Muslim ban case, which he argued in front of the Supreme Court. And I was thinking, it's like,
and lost.
I was like, you didn't help things for us.
No, you didn't. It was not.
I mean, he did the best. It was not his fault on there, but it was obviously these justices came to the conclusion they wanted to, but it's a good example of situational, where they wanted a result in the end, and they were, they were taking positions as far as executive power that in other cases they would have never, in the Biden administration, they wouldn't look at necessarily through the same lens. But that's so I was thinking about our cases because that section of a law for the Muslim ban, that's what's covering our DV cases, our
all the K1 cases.
The K1 cases and all that. That same section of a law was what we've been arguing over and over again. We've had a lot of success actually on arguing on
more than Neil did.
More than Neil did. I didn't want to get. I thought about getting up to the microphone and saying, "Hey, we won on our 212F case." But,
all right, we already kind of talked about I don't think that the WashTech case has much of an impact on the DV case, particularly since Henderson was really all focused upon this idea of, what can the executive do if it's not plain in the statute? I don't think that applies to us. I just don't. She may still stick it in a dissent, but I still feel really good about the appeal. And then our last question, we're still waiting on DV 21. We will not have a decision on DV 2020 or 2021 until January, in my opinion.
Yeah.
Early.
That's it's not happening in the next couple of weeks, people.
All right, everybody. If you want to sign up, go to impactlitigation.com, 2 M's. Sign up for our current suits and pay attention. There'll be more coming up in the next few weeks. Until next week, next Tuesday, we'll see you guys then. Oops.